Good morning. This hearing is called to order. I am President James Brown, President of the Montana PSC and Commissioner for District 3. I'll be the presiding officer of this hearing this morning. Vice President and I will sort of be interchanging the gavel through this hearing. With me today is Vice President Brad Johnson, Commissioner Tony O'Donnell, Commissioner Randy Pinocci, and Commissioner Fielder is appearing via Zoom. Commission attorneys Amy Hockelock and Lucas Hamilton will be advising the commission. Commission staff are also present in the room. This hearing is being transcribed by a court reporter with Lazowski Court Reporting. Do you want to identify yourself? Good to see you, Holly. I would note that if the hearing goes off the record, we will always put it back on the record before receiving more testimony. So for the record, the time is now 9:01 a.m. The date is Wednesday, April 27, 2022. Commission and its staff are appearing from Helena, Montana in the Bollinger Room. This is the scheduled public hearing in docket number 2021.121.134 involving the petition of Caithness Beaver Creek LLC to set the terms and conditions for a qualifying small power production facility pursuant to MCA section 69-3-603. I will now take appearances of counsel. Please introduce yourself and who you are representing this morning for the petitioner.
Thank you, Mr. President. I'm Anna Ketchkesh, K-E-C-S-K-E-S, on behalf of Caithness Beaver Creek.
Thank you, Mr. Chairman. Michael Uda Law Firm, Helena, Montana. On behalf of petitioner.
And good morning, Mr. President. Colson Williams, Uda Law Firm, on behalf of petitioner.
Thank you. On behalf of intervener Northwestern Energy.
Ann Hill on behalf of Northwestern.
Shannon Heim, also on behalf of Northwestern.
Very good. And for the intervener MCC.
Mr. President, good morning. Commissioners, please enter the appearance of Jason Brown, Montana Consumer Council.
Good morning, Mr. Brown. As noted, recesses will occur at convenient times during the hearing. This is always one of the stranger portions of these hearings. I will now ask for public comment on this matter. Is there any public commenters in the room? Seeing none, is there any public commenters online? Seeing none. All right. Staff Attorney Lucas Hamilton will advise if there is public comment, which there wasn't. So we'll skip that portion of the script. Not that I'm reading from a script this morning. All right. Let's move to the evidentiary portion of this hearing. Based on the parties' pre-hearing memos, there are a few items we should address. Northwestern has asked the commission to take administrative notice of its 2019 electricity supply resource procurement plan and the 2020 supplement filed in docket 2019.08.052. Are there any objections to taking administrative notice of those documents?
No, Mr. President, there's no objection. CBC also asked to take administrative notice of the 2019 resource plan and supplement. So no.
No objection. Okay, these seeing no objection, these documents are officially noticed. Northwestern also asked the commission to take notice of the avoided cost information compliance filing and avoided cost narrative summary filed on November 1st, 2019. In docket 2019.08.052. Are there any objections to taking administrative notice of that?
No objection, Mr. President.
All right, thank you. Seeing no objection, those documents are officially noticed. We do have a few outstanding motions to address this morning. First, we have a motion to allow Dr. Mock and Mr. Durkin to testify remotely via Zoom. I understand that this motion is unopposed. Is that correct?
Mr. President, that's correct. CBC does not object to Mr. Durkin and Dr. Mock testifying remotely. I did want to note, though, that with administrative notice, those items, CBC also requested administrative notice of the Montana Sun case.
Okay. Any objection to that?
No objection.
All right, without objection, Montana Sun cases noticed. I
No
didn't figure
objection.
you'd object, Mr. Brown. We're back on Dr. Mock and Mr. Durkin. No objection,
That's correct. No objection.
Mr. Brown.
No objection. Thank you.
Very good. So that motion is unopposed and it's granted. Next, we have motion in limine from Northwestern seeking to exclude certain draft power purchase agreements for the Beaver Creek Wind 2 and 3 projects. I'm prepared to just rule on those motions based on the briefing. I don't think we need oral argument this morning. I'm going to deny that motion. My reasoning is as follows. Both parties are free to argue that the terms and conditions they believe are most appropriate under the circumstances. Evidently, CBC believes the terms and conditions reflected in the draft PPAs for Beaver Creek Wind 2 and 3 are also appropriate for Beaver Creek Wind 1 and 4. Northwestern argues that those draft PPAs do not reflect current information because A, they do not rely on current avoided cost data. They are not final agreements between the parties. They are based on a factual record and procedural history associated with Beaver Creek Wind 2 and 3 projects, and they do not reflect the experience and insight into contracts for battery storage that Northwestern has gained over the last 3 years. I appreciate these arguments. And they are arguments that really go to the evidentiary weight and probative value of the draft PPAs. However, they do not establish that the PPAs have no tendency to make the existence of any fact or consequence more or less probable under Montana Rule of Evidence 401. And more to point, there's very little risk here that their probative value would be substantially outweighed by the risk of confusion under Rule of Evidence 403. CBC has acknowledged and the commission understands that the contracts are not final agreements and based on a different record and do not reflect current avoided cost data. CBC says it has offered draft PPAs to convey CBC's desired structure and terms to apply to BCW 1 and 4 within this docket. The commission will therefore interpret the draft PPAs as nothing more than a demonstrative exhibit showing complete set of CBC's desired structure and terms. Same goes for the proposed PPAs offered by Northwestern. In other words, they are not offered as evidence of admissions from Northwestern. They're not offered as precedent that binds the outcome of this case. They are not offered as evidence on the merit of CBC's proposals. Commission will still expect CBC to present reliable, probative, and substantial evidence supporting its proposals for the contested terms and structure under MCA 2-4704 yes. Where did you? 2-4-704 subparagraph 2 small Roman numeral V or 5. Standard of review for agency findings of fact. The commission expects that the parties will present evidence and argument to support the terms that they would like to include in the PPAs for BCW 1 and 4. So with that explanation, the motion in limine is denied. We'll next take up the motion in limine from Caitness to exclude certain testimony from Dr. Mock regarding Ascend's declining market heat rate. My ruling on that is such this morning. An expert is allowed to base an opinion on facts or data that are not otherwise admissible, provided that they are the type of facts and data that are reasonably relied upon by experts in the field under Montana Rule of Evidence 703. Additionally, an expert may testify in terms of an opinion without prior disclosure of the underlying facts or data unless the commission requires otherwise under Rule of Evidence 705. In this case, Northwestern asserts that it has provided all of the data and the underlying facts that went into its market price forecast. The only allegedly missing element is the process through which Ascend turned those facts and data into a market price forecast. Certainly, parties are permitted to offer testimony from competing experts who use the same facts and data to reach different conclusions. Likewise, parties are permitted to use cross-examination to elicit any assumption or facts underlying an expert opinion. A witness's inability to adequately explain how they use the facts and data to produce their opinion goes to the weight and credibility of that opinion. Unlike a typical jury, the risk of the commission being misled by a baseless expert opinion is minimal. The commission, as you are well aware, has some expertise in this field and can weigh the credibility of the opinions offered based on the testimony elicited by the parties. Given the pre-hearing briefing, I trust that the parties will make good use of their cross-examination and redirect examination to elicit the testimony they believe the commission needs to hear. For that reason, that motion in limine is also denied. All right, let's address the admission of data responses. The parties have filed pre-hearing memos identifying responses they propose to admit into evidence. MCC's pre-hearing memo was the most expansive because it proposed to admit all responses except those specifically objected to. So therefore, Mr. Brown, would you like to make a motion to admit all data responses?
Sure. Thank you, Mr. President. I would move for the admission of all data responses that weren't specifically objected to.
Very good. Therefore, are there any of the data responses that either of the other parties would like to object to?
No objection, Mr. President.
Objection.
Okay. The data responses as moved by Mr. Brown are admitted into evidence. All right, that should take care of the preliminary matters this morning, unless the parties have anything else. Ms. Keshkesh?
Mr. President, CBC understands your ruling on the CBC's motion in limine in regards to Dr. Mock's testimony, but would lodge a standing objection.
Sure, understood and noted. Any other matters? Okay. All right, let's proceed to opening statements. Petitioner CBC, would you like to make an opening statement?
Yes, Mr. President, Mr. Uda will be.
All right, Mr. Uda.
Good morning, Mr. President, Vice President, members of the commission. I apologize in advance. I may slip up at one point or another and refer to you as chair or vice chair. I'm still calling the Los Angeles Chargers the San Diego Chargers. It's kind of sometimes hard to teach an old dog new tricks. I want to start off with saying that it is exceedingly important from my perspective that the commission fully understand its role in this proceeding. In the past, we have had essentially disputes with the commission, not necessarily about the law or the facts, but about the role that this commission serves when it sits in a quasi-judicial proceeding. It is the case that the commission is also a policy-making body. But the commission's opportunity to do that takes place typically within the confines of a rulemaking proceeding. And that is the legislating aspect of this commission's essentially kit. The other part is where you have a contested case and you have parties who are presenting evidence to you. And then the commission's job is to apply those facts to the law. In the past, I've had concerns about the commission blurring those two roles and deciding that because it didn't like something, that thing should not be permitted or allowed. And the reason I'm saying that is I have to say that after preparing for this hearing, I'm a bit gobsmacked here by Northwestern's positions on some of these issues. Keep in mind, this is not the first set of CBC projects. We've already had CBC 2 and 3 come through here. We have a court finding that these projects incurred an LEO. Yet here we have today, Northwestern arguing, I think somewhat implausibly, based on what I perceive to be a strained legal opinion offered by a fact witness, that CBC 1 and 4 do not have an LEO. Keep in mind what the facts presented will show. It will show that these projects have spent millions of dollars to this point. They have completed the interconnection process. They have a signed LGIA. They are currently spending $30,000 a month, excuse me, $3,000 a month to store equipment for their interconnection. The reason they have not completed that interconnection and why they requested suspension in the first place was because we have been locked in a litigation pattern with Northwestern for the past 4 years. So it makes sense, I think, from a commission perspective to think about that, because what happens here is we are required to sign an LGIA. We're required to at least commence the LGIA process. Here we have a signed LGIA. It went into suspension because of litigation. And now we have a pending requirement that when that LGIA is lifted out of suspension, we have to pay $5 million. And we don't have any assurance that we have an economically viable project. I think the question, and it's a fairly simple and straightforward question, is would you pay $5 million for something you didn't even know was going to work out for you? And the reason I'm bringing up these arguments about the LEO is because Northwestern is using this as one of the grounds. They're saying, look, you know, you haven't done the things you need to do because even though you have a signed LGIA and because you've been in litigation for the past 3+ years, you haven't done the things you need to do to make a commitment. That, I submit to you, is frankly absurd. The second reason they offer in terms of their proposed testimony is that they should control the battery. I submit to you, I've been doing this a long time. There is absolutely no LEO criteria that has anything to do with the utility saying that they get to decide the configuration of the project. Keep in mind that what an LEO is, a QF's commitment. There is repeated authority from the Federal Energy Regulatory Commission, from the courts, including the courts of this state, that it depends on what the QF does, not on what the utility does. So what they're saying to you is, we don't like the configuration of your project, therefore you don't have an LEO. There is no support for that whatsoever. And I will attempt to demonstrate that through my cross-examination of Mr. Lefebvre. I think that the reason that this seems so jarring to me is because we have spent the last 5 years arguing about what an LEO is. The commission is currently undergoing a rulemaking to decide what an LEO is, but nobody's proposal was that if the utility doesn't like the configuration of the project or thinks they're operating it the wrong way, that there's no LEO. It's always been things, and this is also in FERC Order 872, it's been things like, do you have land control? Do you have you at least applied for your permits, or do you have them? Okay, do you have a final project design? Have you signed a PPA and sent it to the utility? Have you filed a petition with the commission? That has always seemed to me to be a sufficient but not necessary condition to create an LEO. And yet here we are today, and Northwestern continuing to argue issues that have been well settled. And I would conclude from that their hope is that you will disregard law and precedent both from the courts and from this commission and prior rulemakings, and just adopt a new standard. That is nothing but cynicism. Cynicism that you will rule for them no matter what they say or what they do. I want to change topics here. I want to talk a little bit about the declining heat rate. You're going to hear testimony from Dr. Adam Borison, who has studied this issue extensively. He can find no support from any utility or any forecast for a declining heat rate of the sort that Northwestern is advocating here. None. Even if you look at the graph provided by Dr. Mock, it shows a roughly a 1% decline in the declining heat rate, not an 80% decline in energy prices within 20 years. That is not going to happen. It's not realistic. But again, they are cynically hoping that no matter what the evidence shows, you will just agree with them. Because if they didn't, they wouldn't be making this advocacy to you. I will submit to you that I believe there is very little evidence in support of the declining heat rate. And in fact, when we asked in discovery, and I would remind the commission of this came up again during the jawbone hearing. We said, look, they don't have any evidence in support of this. We asked for it in discovery and they wouldn't give it to us. And you said you should file a motion in limine. In this case, we not only requested the specific information in discovery about how you calculated this declining heat rate, we then filed a motion to compel, and Northwestern didn't answer at all. I do believe that the president is generally correct when he says that the commission can weigh evidence, but there is no evidence here. This is a party who has claimed that the Loch Ness Monster exists. We've asked them for their proof, and they've said, we don't have any. Just trust us, the Loch Ness Monster exists. This is an extraordinary claim to say that energy prices are going to just crater the way Northwestern claims they will. But extraordinary claims require extraordinary proof. If you're going to claim the Loch Ness Monster exists, you better be ready to provide that evidence, and it better be good. The next thing I want to talk about is variously referred to as, I guess, the marginal cost to serve load. But the real issue that we're concerned about is this valuing power on condition 3 at 0. That is based purely not on evidence, but on a legal theory, all based on FERC Order 69. They first brought this up during the Great Cliff hearing, and this commission told them to go to FERC. They did go to FERC. They argued it as a matter of law, and FERC said, we don't have enough evidence to show that any particular resource is causing you to be long. So they've made sort of, I don't know what you'd call it exactly, less than complete attempts to show that, but they still haven't shown it. It's based on their interpretation of PURPA. That's what it's based on. And PURPA requires two things. I will remind this commission. One is that you adequately encourage these projects to be developed. That is congressional policy. And two, that ratepayers should be indifferent. Well, it basically says that rates should be just and reasonable, but the way that people have been referring to it, I'll just accede to that characterization. Ratepayers are not indifferent if, because of Northwestern's proposal, ratepayers are going to be subsidized to the tune of $140 million. And that is what Mr. Schiffman's testimony will show. It's a cost shifting. They're not indifferent. They're actually benefiting. You're taking money from one pocket and you're putting it in another. It's that simple. Next item I would like to talk about is this whole concept that with respect to capacity, that what CBC is doing is somehow novel or unique. The testimony that you'll hear from Mr. Grant is as follows. We took the first CBC case, CBC projects 2 and 3, up on appeal. And the court basically remanded it back, but I think the court generally agreed with what the commission did. So Mr. Grant, after the order came out from the commission, they used in the first year the ELCC and then used the SPP method to measure and pay. And that's the proposal here. It's not unique. It's not anything extraordinary. It's just a matter of Northwestern wanting the capacity payment to be lower. That's all it is. I also want to mention there is another issue that we find concerning, and it has to do with the measure and pay itself. We have a proposal on measure and pay that we think is fair and consistent with prior commission precedent. I should mention, changing topics, that we also believe that there should be a carbon adder. We understand this commission's prior orders, but we're going to put the record evidence in anyway on that. We don't agree with the commission's decision, but we do understand the parameters of it. I think that there will be other issues that will come up during this proceeding, but I think the main focus of this commission should be, what do the facts show you and how they apply to the law? I am concerned that Northwestern seems unconcerned itself about the radical nature of the proposals it brings to you today. There's nothing consistent with what this commission has done in the past in anything that they're doing. They have proposed a declining heat rate. Yes, in the past, the commission has approved that. But there's no evidence for it at all in this case, and that is what the testimony and exhibits will show. They have proposed no LEO, even though that is not consistent with any prior precedent of any court or this commission. They have argued that they've even argued with the contract terms, which really doesn't amount to anything because it's just like, this is what we want, this is what they want. At some point, you just conclude that people want to argue because they want to argue. They have a motive for it. And I do want to make this part of this absolutely clear. When you look at issues like the liquidity of the forward market curve, we've argued for 2 years because we think that is what the evidence supports in terms of the end of liquidity, essentially. We asked Northwestern for evidence to show that 4 years is the right period of time. And what did they say? Is we don't have any evidence. It's just a policy. It's just the thing we're doing now. My concern about that is twofold. One is, if I punch you in the face and then I punch myself in the face, am I not injured? I think I will argue that I am. Secondly, Northwestern does not recover its expenses and its capital costs the way we do. We recover it through a single contract over time. We have to make that go over that period of that commitment. If we don't, we're subject to penalties under the contract. We're subject to termination. If a utility asset underperforms, they can come back to you and say, we need more money. If, for example, Colstrip Unit 4 shuts down for whatever reason, they have to go to market to buy power to replace it, and they expect you to approve that. And I realize that there have been times in the past where you've said, no, we're going to discount that. My point is, they're not locked in, not the way we are. And also, once they put something in rate base, that's in customer rates forever until they decide basically that that commitment they've made to that project is finished. So when they say they're applying this to themselves, they're not locking themselves in the way that we are. We are trying to be maximally prudent in the way we construct and operate this facility. We believe that the rates that we have in our proposal are appropriate. Are they 100% right? There's nothing 100% right in any of these proceedings. You all know that. But we're all trying to take our best guess as to what the future looks like. If I had to guess, would I guess that there was going to be an 80% decline in energy prices in 20 years? No. What we're seeing now is a temporary situation, perhaps. Maybe temporary, may not be. We're in an inflationary environment. We were in a deflationary environment for a long time. And, you know, when energy prices were low, we argued about prices in the 30s. We couldn't get approval for some of those contracts from the commission, and they look pretty good in the portfolio right about now. So you're going to make mistakes. The question is this a good project? Answer, yes. Do we know that batteries make sense? Yes, we do. How do we know that? Northwestern itself is proposing a battery as part of their Beartooth ESA application. So in retrospect, I am surprised after reviewing Northwestern's application that they have made what I perceive to be radical arguments. The argument about the LEO, refusing to produce the actual analysis that shows a declining heat rate, the not producing evidence to show that should be 4 years for the forward curve instead of 2. I just believe that they just believe that you're going to vote for them no matter what they say. And I would urge you to carefully consider the evidence and follow the law and rule in favor of CBC 1 and 4. Thank you, Mr. President.
Thank you, Mr. Uda. Ms. Hill?
Mr. President, if I could, I'd like to make my opening statement at the beginning of my case.
Noted. Mr. Brown?
MCC would also defer until our case in chief.
Very good. All right, Mr. Uda, your case in chief.
Thank you, Mr. President. At this time, I would call Mr. Narenberg.
Yes, you may. All right, so before we have Mr. Narenberg testify, I would like anybody that will be a witness during this hearing to please stand and raise your right hand, and I'll just swear you in at once. All right. Do you swear the testimony you're about to give is the truth and nothing but the truth?
I do.
Very good. I would just remind council that if any of your witnesses are not present for that swearing in, please notify me at the time the witnesses are called to testify, and we'll get them sworn in at that time. All right, Mr. Uda.
Thank you, Mr. President. Good morning, Mr. Narenberg.
Good morning.
I really hope that you have in front of you a document that is titled Pre-Filed Direct Testimony of Ron Narenberg on behalf of Caithness Beaver Creek LLC.
Yes, I do.
Do you recognize this document?
I do.
Did you cause this document to be prepared?
Yes, I did.
And if I were to pose those same questions to you that are posed to you in your direct pre-filed testimony today, would your answers be the same?
Yes.
And do you have any additions or corrections to make to your testimony?
No.
At this point, Mr. President, I would tender Mr. Narenberg for examination.
So,
Northwestern doesn't have any cross for this witness.
Brown?
No questions. Thank you.
Right. At this point in time, I would remind my colleagues that to please keep your cross-examination questions limited to and relevant to the testimony that's being given by the witnesses. That being stated, any questions, Vice President Johnson?
No questions, Mr. President.
Any questions, Commissioner O'Donnell? Any questions, Commissioner Pinochi? Any questions, Commissioner Fielder?
No, Mr. President.
Right, and I don't have any questions for this witness. Mr. Ruda?
Seeing that there are no questions, I forgot to move the admission of
Yes,
CBC
you
1.
did.
So if we could move for its admission and the commission could agree to it, I would greatly appreciate it.
Thank you, Mr. Ruda. Is there any objection? So,
No objection.
Mr. Brown? Seeing no objection, CBC 1 is moved into evidence.
And Mr. Chairman, may Mr. Narenberg be permanently excused?
Ms. Hill?
No objection.
Mr. Brown? Mr. Narenberg, easy morning for you this morning. You are permanently excused from this hearing.
Not all dressed up with no place to go.
Yeah, well, thank you. And just want to thank the commission for allowing me to do this by Zoom as opposed to coming to Helena for such a short testimony. Thank you.
Thank you. All right, Mr. Ruda.
Thank you, Mr. President. This time I would call Roger Schiffman to the stand.
All right, Mr. Shibman. You may.
Mr. Schiffman, a document has been placed in front of you that is referred to as the pre-filed direct testimony of Roger Schiffman on behalf of Caithness Beaver Creek LLC. Do you recognize this document?
Yes, I do.
Did you cause this document to be prepared?
Yes,
And contained in this document is a series of questions and answers. And if I were to pose those same answers to you today, would your answers be the same?
yes.
Do you have any additions or corrections to make to your testimony?
I have two corrections. In terms of the avoided energy costs that are presented in tables 1 and 2. In response to data request PSC 007, we had changed the methodology to basically accept Northwestern's calculation for levelizing the avoided costs, which resulted in revision to the avoided energy costs of around 50 cents per megawatt hour. So there were revised numbers that were presented in response to PSC 007. So those are the official numbers that CBC is promoting. So the tables in my testimony would be revised accordingly and the associated testimony.
Mr. Schiffman, could you direct us to where those tables appear in your testimony?
Table 1 is on page RS 14. Table 2 is on page RS 15.
Okay, so at the bottom of table 1, it appears that you have an ATC, meaning around the clock, all net avoided energy price of $20, 20 years at 55.72. So what should that number be?
Should be 55.18.
And similarly, on page 15, you have table 2, and you have an around the clock number with a net avoided energy for a 20-year PPA of 55.17. What should that number be?
That should be 54.48.
Do you have another correction or revision to your testimony?
I do. Tables 4 and 5, column 2 should be labeled as dollars per ton rather than dollars per megawatt hour. And those tables are on pages RS 19 and RS 20 respectively.
And so in the final column, you have levelized avoided carbon costs for a 20-year PPA of $11.07. Is that correct?
Yes, for Beaver Creek Wind 1.
And what should that number be?
No, the numbers are correct. It's just the column label in the second column mistakenly referred to dollars per megawatt hour. It should be dollars per ton.
Oh, okay. And the same is true for on the next page, RS 20 for the table that appears there.
Yes,
And that's the same correction.
yes.
Are there any other corrections you need to make?
Just to clarify, Mr. Udine and Mr. Schiffman, you're looking, so for example, on table 4 on RS 19, you're looking at the second column, is that what?
Yeah, the column, the first column with numbers that aren't years. So it's labeled KISO carb
Okay.
CO2 dollars per megawatt hour. That should be dollars per ton. Mr.
All right.
President.
Very good. Thank you for clarifying.
And just to clarify, that would be on both.
That would be on both. And we discussed that in response to I'm sorry, I neglected to write down. It was another PSC data request, but I didn't write down the number of it.
At this time, Mr. Chairman, I would move for admission of CBC 2.
No objection.
Mr. Brown? All right,
At this time, I would tender Mr. Schiffman for cross-examination.
hold on, Mr. Udine. CBC 2 is admitted.
Oh, I'm sorry, Mr. Chairman. Mr. President, sorry.
It's all right.
I knew I was going to do that.
All right, Ms. Hill.
Mr. President, before I start the cross, I'm going to be referring to some documents. May we approach?
You may. I would just note for the record at this point in time that Commissioner Fielder will not have the benefit of having these documents in front of her, I believe.
Mr. President,
Mr. Fielder?
we could just have the set of those be given to our staff for my inbox there at the office. That'd be great.
Yes, we've already arranged for that. Thank you, Commissioner.
Thank you.
All right, Ms. Hill?
Good morning, Mr. Schiffman.
Good morning.
In your exhibit RS1, you provided the forecast that you used in calculating avoided costs, correct?
Yes,
And just for the record, Mr. President, the exhibit 1 is pre-filed in the record. And in front of you, the one-page document that has the green markings on it, that's an excerpt of that forecast, correct, from exhibit RS1?
subject to check. Yes, I believe so.
And is this your forecast of future market prices?
Yes,
And does the forecast use the 2021 EIA, AEO, Henry Hub natural gas forecast?
yes,
But you didn't provide any model of the 2021 EIA, AEO, Henry Hub natural gas forecast in with your testimony, did you?
I didn't. We had basically relied upon Northwestern to produce that curve based on assumptions about how to do it.
But you correct me, you just stated this is your forecast, correct?
It's the forecast that we asked Northwestern to develop on our behalf, yes.
Is it CBC's forecast in this docket?
It's the forecast that we're relying upon in this docket, yes.
Do you stand behind this forecast?
Yes.
But you didn't develop the natural gas escalator, did you?
I did not. We asked Northwestern to develop the gas forward curve using the EIA escalation, which the reason we asked Northwestern to do that is because that was a past commission precedent.
And that's really just a simple escalator, right?
Yes.
So let's look at this exhibit, this RS1 that I handed out. You forecast prices to exceed $70 from 2031 to 2045, correct? For the peak, I'm sorry. If you can look at the peak column, from
You-
2031 to 2045, you forecast the price to exceed $70, correct?
The price exceeds $70 beginning 2033 on this table.
If we look at the peak column
Yes,
and we look at the year
yes.
and we see 2031, does that say $70.90?
2031, yes. Sorry, I was mixing. There's some years over here. I misread the column. There's two columns of years here.
Do these prices in your forecast contain a cost of carbon in them?
No,
So your forecast, taking my example of 2031, is that the market price would be $70.90 and then add on maybe another $5 for carbon.
yes,
You discussed in your testimony your concerns about subsidizing Northwestern's customers, correct?
yes,
And you just testified that you expect market prices to escalate, correct?
yes.
So wouldn't an avoided cost of energy payment based on a local marginal price alleviate your concerns about ratepayer subsidies?
I don't believe in the avoided cost methodology utilized by the commission that is a methodology that's been employed.
Right. I'm asking you if that would alleviate your concerns.
If there was a visible market price that was credible and consistent and applied, then it wouldn't create a subsidy, right?
And is a energy imbalance market node a credible price?
It's a credible price, but it's a balancing market. It's not like a day ahead market. So the volumes are limited. It's got different price dynamics than say a day ahead market would have.
So let's look at table 8 in your, I believe it's in your rebuttal. Let me check.
Mr. Chairman, Mr. President,
Mr. Udo.
sorry. She's asking Mr. Schiffman about an exhibit in his rebuttal testimony. And I don't believe that we are presenting our rebuttal testimony at this time. If Ms. Hill wants to ask him about that table when rebuttal testimony is entered into the record, I think that's fine. But for now, I would prefer to just focus on his direct testimony.
So,
That's a fair point. Just because we've done these hearings differently, can I just clarify? I didn't catch that. The order of our witnesses will be that they're going to do all of their direct, then Northwestern, and then the MCC, and then all their rebuttal. I apologize for not clarifying that before.
It's okay. I mean, it wasn't entirely clear to me until yesterday. So I think that's what our proposal is to put on our direct testimony first and then do our rebuttal testimony after the interveners have gone.
Very good.
Okay, I asked the commission's patience because I've never had that before, so it might take me some time to.
Mr. President, but for clarification, it would seem to me to be more understandable to me if the rebuttal testimony is going to color his testimony here. It would be better to understand the direct testimony if there's some material change, if that's what you're looking for.
I'm fine with the order that's been proposed by the parties.
Okay, I can accommodate you just 1 second. Mr. President, I think most of my questions are going to be for rebuttal. Could we go off the record?
Yeah,
for a
Mr.
second?
President, I was going to suggest we give, because she wasn't anticipating this, we give Ms. Hill a few minutes to figure out what she wants to ask.
I'd like to go off the record for a second.
Sure. Time is now 9:53 a.m. We'll go off the record.
So,